Hello everyone. For today's Murphy Law Monday, I want to explain what a modification is in the state of Maryland and in the District of Columbia, and why and what you need to prove in order to receive a modification in these locations. Now, generally speaking, a modification is a request of the court to change an existing court order. And you could have a myriad of reasons as to why you think that the court should change the order, but I think having the mentality that the order was initially either agreed to by the parties or the court heard an entire trial on the case and made the order has to be at the forefront of your mind. So in order for them to undo what they've already done, they need a basis for it. And a basis is not the other party and myself no longer speak, or we can't communicate, or this just isn't working, he's late all the time. It has to be kind of over a period of time. So what I usually tell my clients is to document things, to document the late arrivals, to document the tardy arrivals to school, to document the fact that you told the other party that you were moving from Maryland to Florida, or that you told them that you disapproved of them moving from Maryland to Florida. I think that all of these things have to be documented so that when you go before the judge, of course, noting that it's always going to be your word against theirs, you will have enough information to put before the judge as to why you believe that this particular situation should be changed in the child's best interest. And the child's best interest, again, is the forefront. There has to be a material and substantial change. There can't just be some change that you again don't agree with the order. Oh, I don't think this is going to work. I don't think we should have 50-50 custody because he's not a good parent. If the judge had a trial and they determined him to be a fit parent, then you best believe that they're going to leave their order in place unless there's a showing that he's not. And I would say it's not necessarily your job to prove that he's not, but I think that you want to keep at the forefront that in a modification proceeding, that is what the court is looking for. So you don't want to waste time and money and energy in filing a modification that has no merit. Things that I've successfully modified, basis for modifications that I've been successful with, include but are not limited to relocation. One parent initially was living out of state and now has relocated back to Maryland. Another example would be the child has gotten up in age. So when the order was issued, the child was 3 years old. Now he's 16 and he has a voice and he wants the court to hear him out on the fact that he might want to primarily live with his mother, that 50-50 custody doesn't work for him anymore. He has a basketball schedule. He has a whole life, and that's why he wants the court to modify the order. Another reason and basis could be that the parties have essentially gone off the record and done something different. So if you and the other party agreed, hey, I know we have this, I have primary custody, but we've been doing 50-50 for the last 3 years, but you never put it in writing. And now you file this case and the other party, of course, wants to now magically go back to the order. I think the better protocol is once you guys agree to change the order, that you do so in writing and then you file the case immediately while you guys are on the same page. Another basis for modification, not necessarily relating to custody, but more so child support, is increases or decreases in income. I know that, for example, work-related childcare expenses are very expensive in this area. So, of course, when child support is initially entered, the amount is very high because of daycare. But let's say now 3 years pass, the child is in primary school. That is a basis for you to modify a child support order on the grounds that there is no longer this substantial daycare amount that needs to be paid, and therefore the child support should be modified accordingly. Another example of a child support modification issue that I've seen myself is the medical expenses, the insurance that you pay monthly. And sometimes people's families expand, so a family plan is more lucrative and easier to maintain. They change their child once, just paying for them out of pocket, now paying for 2 other children, so it's a little less expensive. That's the basis for a modification. I just think that it's important to keep an open mind and to keep records of everything that you do and all communications you have with the other party during a modification proceeding, keeping in mind that the courts usually do not undo what they just did unless there's a real reason why they should. And I would say that that's a very high burden, a burden that you should not go along, a burden that you will definitely need counsel in order to fulfill and or guide you through the process as it is unfolding. If you're in need of legal services in the state of Maryland or in the District of Columbia, please give my office a call, 240-493-9116 and www.amurphylegal.com. Thank you.